Welcome to The Fine Print, the podcast where we explore the law, its impact, and the people who shape it. I'm your host, Riddell, and on today's episode, I'm thrilled to welcome Advocate Akshit Mago. With specializations in commercial litigation and international arbitration, he's represented multinational corporations and sovereign states across major sectors. His work spans from high-value disputes in India to investor-state arbitrations in London. Advocate Mago also earned his advanced LLM in international dispute settlement and arbitration from Leiden University, graduating cum laude, cementing his reputation as one of the leading lawyers in global dispute resolution. So, to start us off, how did your journey into international arbitration and commercial litigation begin?
First of all, thank you so much, Rudel, for having me on this podcast. And I hope I'm able to shed some light on my practice area and my experience. But to begin with, to answer your question, so my journey began fairly early in law school as far as commercial litigation and international arbitration is concerned. Initially, I was drawn to disputes work because it offered a mix of strategy, advocacy, and problem solving. But it was international arbitration in general that truly opened my eyes to the global dimension of disputes and the enormous potential that it has in terms of affecting various stakeholders in the global arena. My first experience of international arbitration was actually through the Willem C. Wiz Moot, which was held in Hong Kong during my time. And it really gave me a glimpse of cross border commercial conflicts and all the procedural complexities and sophistication that arbitration usually includes to resolve such commercial conflicts. And that experience was a great learning curve, and it really, gave me the taste of international arbitration and the potential it has. And I really, really wanted to explore it further. However, since I started my career in Delhi, India, after graduating from law school, I started focusing on commercial litigation generally before domestic courts. But I was fortunate to get my hands on about three or four international disputes at that time, all of them to be resolved through arbitration. And it was a mix of experience in the sense that I did a commercial arbitration, which was London seated. I got the chance of working as local counsel for an international law firm that was representing an investor in an investment treaty arbitration against the Republic of India. And so over time, that blend of courtroom work before domestic courts and cross border arbitration really became the foundation of my practice.
Thank you for sharing your journey and, explaining how your arbitration passion kind of stems from a moot that you experienced. And that journey kind of keeps growing. And clearly, your high value and high stakes cases have shown the immense growth and amazing, reputation you have as a lawyer. So, for listeners who may not be too familiar with these fields of law, could you explain a bit about each one and how they differ?
Sure. So see, essentially, litigation and arbitration are two different tools and ways of resolving a dispute. When you add the commercial element to it, it only shapes the kind of dispute that is being resolved. So essentially, the question is one of difference between litigation and arbitration, because otherwise, the commercial element is just to do with the nature of the dispute and nothing else. But as far as a broad comparison between the two processes is concerned, litigation is the process of resolving disputes through national laws before domestic courts and forums. And such forums can be specialized in handling a specific type of dispute, or maybe in general, enabling and helping citizens and various litigants to approach them to for resolution of their disputes. A few elements peculiar to litigation are that you don't have any choice of what procedure will be followed. You don't have much choice about what would be the governing law over the substance of the dispute. So, in case if I'm an Indian entity or an Indian citizen filing a case in one of the Indian courts, I am submitting myself to the jurisdiction of that court. And the jurisdiction of that court is something I cannot tamper with or dictate or choose, because it'll be the law of the land that will apply, which in this case, in case of litigation before an Indian court, would be the Indian law. So it doesn't matter of which country you're a citizen of. If you're filing a dispute in India, there are certain essentials that it has to meet, and it would always include no flexibility on the choice of procedure and the choice of law that will apply. And obviously, the most obvious other difference being that the outcomes are decided by judges, in contrast to arbitrators in arbitration. But yeah, at the same time, as far as international arbitration is concerned, it's basically a private dispute resolution mechanism which is used by parties from different countries who want a neutral, specialized, and enforceable forum to adjudicate their disputes. In arbitrations, the parties not only decide what the governing law applicable to the substance of the dispute will be, but they also decide the procedural law that would govern the conduct of arbitration proceedings. So, for example, if there is an Indian entity who has a dispute against an American entity, so both of them, when they're entering into contract to govern their business relationship, they can decide contractually how they want the dispute to be resolved. So basically, they will say, we want the dispute to be resolved through arbitration. Now, what will be the law that will apply? Indian entity would say we should apply Indian law. American entity would say we should apply American law. So there will be a deadlock. So then what the parties would do is they will be like, okay, according to us, English law is the most developed. Let's apply English law because it is common law, and Indian law and American law have elements of common law. So let's select a neutral governing law clause. Then comes the procedure. What language to follow? Where will we have the arbitration sitting? Which institution will govern the arbitration? All of this is completely in the hands of the two entities, and they can decide however they want their disputes to be resolved. And most essentially, they also get to choose who will decide their dispute. In some cases, arbitrations can be ad hoc, basically, where everything is done by the parties. They select who the arbitrator will be. Second would be institutional arbitration, where you would approach, say, a London LCIA, and you ask them that you nominate an arbitrator for us. So they'll have a roster of arbitrators on their panel. They will recommend a name, and you choose from that name. So the constant is that the parties are always free to choose their arbitrator, apart from the governing law and the procedural law that is involved. So essentially, the difference is twofold. One, in litigation, there is no aspect of neutrality because a party would always have the home court advantage. But in case of international arbitration, that neutrality is really embedded in the entire process because there is never really a home court advantage because everything is being done through mutual consent and through mutual agreement. And the other aspect, obviously, is that of enforceability as well, because an arbitral award, depending upon who the entities are involved, what are the rules, etc., is 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 enforceable in terms of the New York Convention. And irrespective of where the assets are located, the party in whose favor the award is can approach any country and enforce the award. Whereas when it comes to litigation, the enforceability can sometimes be a problem because if a national court is passing a judgment, then it will be enforceable within that country. You can enforce it in another country as well, but then you have to abide by whatever processes are applicable to such decrees or judgments, as we call them in litigation. So both dispute resolution tools are different, but they differ from each other in terms of strategic needs and also what the parties want. But both are at the same time really effective in resolving disputes.
That's a great summary of both those fields. And, notably having these elements of choice and the elements of like neutrality as well as enforceability shine through the different elements. So, focusing in on litigation, in your view, what qualities distinguish a qualified litigator from others?
I mean, to be candid, it takes a long time even for practicing litigators to really realize what really works for them and what doesn't. But if I were to generally talk about the most common and most effective qualities that a litigator should have, I would point my finger towards three qualities. The first would be clarity of thought, because especially in commercial disputes, there is immense complexity involved. The transactions are complex, the position of parties is complex, the disputed questions of fact are complex. So it's really important that a litigator is able to simplify commercial disputes and complex disputes into sharp, persuasive narratives. Because if you're not able to distill complex disputes into something simple and easily being able to communicate with the judge or the arbitrator, obviously, I mean, we are focusing on litigator, but still, you will not be able to convey the message across, and you will not be able to really make the point. So that is, I think, the first and most important quality that a litigator should have. And that also helps the litigator in communicating with their client, because how a client understands a dispute versus how a litigator understands a dispute and is able to really counsel the client are completely different. Second would be, for sure, preparation and precision. A litigator is only as good as their command over the facts and the record. So, I mean, a sign of a good litigator is that he or she or they should be fully prepared, should know all the facts, what are the important documents, agreements, communications, and precision. What argument to make using which document, how to convey dates, factual scenarios. So it's extremely important that a good litigator is well prepared and is precise, both in terms of words and how the dispute is interpreted and understood. The third would be judgment. So this would involve knowing when to push, when to retract or take a step back, when to negotiate hard, when to play good cop, when to play bad cop, and also to have an understanding of what battles are worth fighting. So this also comes with a lot of strategic considerations and experience. I firmly believe in something I call as the art of silence. So when a litigator is arguing a matter, it is really important for the litigator to stop arguing and listen to the judge if the judge is trying to say something, and not to jump to conclusions. Really understand the perspective that the judge is sharing, the point the judge is making, the question that the judge is trying to ask. And also at the same time, if you have an opposite side who's constantly intervening, it's good to just be quiet for a while so that the judge is really able to see who's trying to conduct the proceeding in what manner. And sometimes an overeager litigator spills the beans sometimes in their eagerness to either defend a point or counter a point or to make a point. So it's really important for a good litigator to exercise judgment in all these situations, and as much as possible practice the art of silence.
That really makes a lot of sense. And, I'm sure litigation cases are extremely complex. So being able to manipulate and kind of maneuver around these three main skills that you mentioned are the key qualities and really distinguishes a qualified litigator from others. So
Yeah.
adding on to litigation as a whole, how important is cross-disciplinary knowledge in commercial litigation?
Oh, it's extremely important, and with time, it's gaining a lot of importance as well, because disputes today involve finance, technology, energy, antitrust, regulatory frameworks, sometimes all at once. Whether in talking from experience, whether representing a media company in a high stakes copyright dispute involving AI, or handling large infrastructure, aviation, and financial cases, you quickly realize that legal analysis alone isn't enough. And it's really important for even a litigator to have cross disciplinary knowledge, because it allows the litigator to speak the language of all the different experts that would usually be involved in such disputes. So it's important that given the nature of the dispute, a litigator is able to speak the language of an economist, an engineer, a technologist, or even a regulator. And that often becomes the key to winning complex cases, because it is not just the knowledge of law, but the understanding of the ground realities involved in commercial dealings that really helps in understanding the dispute and devising a winning strategy to succeed in any given case. If a lawyer is far away from the ground reality, is not aware how a specific business or their client's business works, and what all different cross disciplinary specializations are involved, or the impact that is there on the dispute, then the litigator won't be able to make the point that is required to be made, because a law is always applied on the specific facts of a case. Law cannot ever be read in isolation, especially for a litigator who's litigating a dispute. So it's really important. I can't stress enough on how important it is to have cross-disciplinary knowledge. And all of even litigators are learning every day. So even though their command on law may be excellent, but obviously every case comes with new challenges, new areas. So it's really important.
I can imagine that must be complex and tricky overall just to navigate these different fields, and how the use of this cross disciplinary knowledge and, in your words, speaking the language of so many different fields would really aid the litigator in making their case more poignant. So, moving on to arbitration, you mentioned earlier how arbitration is led by neutral third parties. So, what are some of the advantages and drawbacks of resolving disputes through arbitration?
So this is an ever-present debate as far as arbitration is concerned. Because initially when arbitration came about, you had various proponents of arbitration. Everyone was praising arbitration because it was a new, refreshing change from how disputes were classically resolved in any given scenario. So, the main advantages that are still present to a large extent would be, as I had earlier highlighted, neutrality. And the impact of this neutrality is especially important and especially noticeable in cross border disputes, where parties are from different nationalities. They want to ensure that the disputes are resolved by arbitrators who are as neutral as possible. The basically they want to ensure that there's a level playing field, whether it's any aspect of that entire arbitration. So I would say first is neutrality. Second would be expertise, because since the parties have the option of choosing and nominating their arbitrators, they also simultaneously have the benefit of choosing arbitrators who would be best suited to resolve a particular type of dispute. So, for example, if there is a construction arbitration, then parties can decide to appoint someone who has technical knowledge on what it takes to actually construct, say, a 8-lane highway in Dubai or a skyscraper in Abu Dhabi. So it is extremely important. And one of the advantages is expertise, that parties can really come together and have an expert determine their disputes rather than submitting to a domestic court's jurisdiction and not having any control over which judge decides the dispute and whether or not that judge has the knowledge. Third advantage would be flexibility. This, I think, since arbitration came into being till now, is one of the best advantages of arbitration, because parties can tailor procedures, they can decide where they want to sit and do the arbitration, they can decide the rules, they have the complete control over how their disputes are resolved. The last would be a slightly controversial one, but since classically that's always been seen as one of the advantages of arbitration, I would say enforceability as well. So initially, the idea of arbitration was one, it is a speedy way of resolving a dispute. Two, the award that will be passed would be final and binding on the parties. And it'll be easily enforceable against them because they are themselves submitting to the jurisdiction of the arbitrator and the arbitration to resolve their disputes. However, over time, and I'm going to use this as a segue into the drawbacks, over time, enforceability has become a big problem now. And every year for the last 15, 20 years, there are new challenges that keep coming about as far as enforceability of arbitration awards are concerned. Sometimes parties are not able to trace assets of a judgment debtor against whom an award has been passed. Sometimes parties are completely unfamiliar with the national laws of a country where such assets may be located. And there is complete uncertainty as well as far as enforceability is concerned. Because even once a party has an award in their favor, they struggle to reap the benefits of the award. And that is mostly because of such national and logistical issues where they don't know where the assets are, or they later realize that they were only fighting against a subsidiary and they don't know where the parent is. The subsidiary has no assets. So that is a big problem. The second drawback would be cost. Arbitrations can be expensive, they can be extremely expensive, especially institutional arbitrations, where you're not only paying the arbitration fee, which involves administrative costs, arbitrators fee, but you are hiring or you want to hire the best international law firm to handle your case, and that involves a lot of litigation expenses towards the fee of the solicitors, the lawyer, the law firm, paralegals, etc. The third drawback would be speed. Even though arbitration has always been marketed as a speedy tool to resolve disputes, but over time, we have seen that arbitrations can take time, depending upon how complex or voluminous the disputes are. And then there are other complexities involved. Sometimes a dispute has to be bifurcated into two proceedings, where first you have to satisfy the jurisdiction of the arbitrator. So you first complete pleadings on jurisdiction, you make arguments on jurisdiction, the award gets reserved on jurisdiction. Then the arbitrators determine that yes, we have jurisdiction. Then you move on to the merits of the dispute. And then you have the entire trial, expert evidence, so on and so forth. In my experience, I have seen international arbitrations even going on for 4 or 5 years. So, there is a strong argument on how speed can be seen as a myth as far as arbitration is concerned. So, those are the pros and cons, right? It's a constant balancing act, because even though it gives flexibility to parties, sometimes parties can misuse that flexibility and just make the process a little more cumbersome than it's required. And then comes the ever present problem of the enforceability, as I had earlier mentioned. So, there are parties who at a drop of a hat go and challenge awards, and there is a completely different procedure which applies to challenging awards, but that throws the final and binding aspect of awards for a toss, because depending upon what national jurisdictions are involved, what rules of arbitration apply on a particular arbitration, the parties can easily use or misuse domestic courts of a particular country, depending upon, again, what rules are applying, to challenge awards and stall any enforceability proceedings as well. So it arbitration does come with its fair share of pros and cons, but I think the pros in the right situation easily outweigh the cons.
Mm. That's a really clear breakdown of arbitration and just the advantages and disadvantages as a whole. And you very concisely broken them down for our audience. So, furthermore, what are some common challenges that arise in cross-border disputes when it comes to international arbitration? I know you mentioned a lot about enforceability, but are there any other kind of challenges that are quite poignant when it comes to arbitration or arbitration cases?
Oh, absolutely. And the challenges that I will highlight are actually peculiar and specific to international arbitration, given the cross-border nature of these disputes. So, as I briefly mentioned, but the first one would be jurisdictional objections. In most high stakes commercial arbitrations, or especially investment treaty arbitrations, it's almost imperative and it's very easy for parties to raise jurisdictional objections. Such jurisdictional objections can be multifarious, and but they're extremely common. And this usually is peculiar because parties fight over what law will apply. Sometimes there is ambiguity in clauses. Sometimes parties mention two different laws will apply depending upon where the dispute is being resolved. So this often invites a lot of jurisdictional objections. And these jurisdictional objections are commonly raised also because if a party succeeds on their jurisdictional objection, then the proceeding comes to an end if they succeed. So they would not have to go ahead with the merits assessment, then the quantum aspect of damages, if at all they succeed on merits. So it's the easiest and most effective way of succeeding in an arbitration quickly, is where you're able to raise jurisdictional objections and you succeed on them. But this also then comes in the form of a challenge, because what if the jurisdictional objection was frivolous? What if the jurisdictional objection was taken simply to delay the matter or frustrate the arbitration proceeding? So, but however, unfortunately, as soon as a jurisdictional objection is raised, it will necessarily have to be adjudicated upon and determined, because it goes to the root of the matter. Because if a tribunal does not have jurisdiction, it cannot adjudicate the matter. So that would be the first challenge, according to me. Second, and the most prominent one, is the involvement of different legal cultures. So you can have an Indian party arbitrating against an American party, and the arbitrator is Korean, for example, and or Singaporean, for example. I would take a more drastic example, which is that of a Korean arbitrator, because their entire foundation of law and understanding of law will be completely different from what an American or an Indian lawyer's understanding would be. But at the same time, since the parties have chosen the Korean arbitrator to arbitrate, considering neutrality and fairness, they will have to face this issue as well, because there would be some limitations on what how the law will apply. And this may be true for any arbitrator or counsels who are from different legal schools as such. There can be a civil law pitted against a common law lawyer, and vice versa. And this also affects uh, experts. So it's quite possible that in such a situation where there's an Indian party against an American party, a Korean arbitrator, but now you're looking for an expert on a specific issue, and the only expert available is from a fourth jurisdiction. So then, how do you bridge the gap? And the gap can be of several aspects: communication, understanding various systems, how one mind works, how there are different approaches, and there are cultural elements also involved. So that is again a challenge that frequently comes. And here again, the skill of the council really comes in, because they really need to adapt to what approach they have to follow. Because as I said, the idea is clarity of thought and conveying information in the most simplest of ways. So it really affects how a council or a council really communicates and argues the matter. Third would be the aspect of evidence. So how does one obtain documents? Where is the witness coming from? Which witness to call, which not to call? Financial records. What if one of the entities has their entire records with a Swiss bank? Because Switzerland as a country is extremely protective of financial information that is present on their soil. Banks are under no obligation to disclose financial records. It doesn't matter which country, which tribunal, which arbitrator. So that also becomes really tricky and difficult to navigate, because a Swiss bank will never allow even a single piece of paper to leave the bank, whether electronically or physically. So that also becomes a big challenge. And yeah, those are the three main challenges apart from enforceability, which I think, addressed quite a bit already.
Those are some very valuable insights. And I honestly hadn't considered it that way, that there were so many different facets to arbitration and summarizing, having jurisdictional objection and different legal cultures, as well as the challenge of kind of having evidence, all plays a part into arbitration as a whole. So, with our world constantly changing, a question I have that kind of encompasses both commercial litigation and international arbitration is, how do you see these two fields evolving over the next decade, and especially considering the increase of globalization and geopolitical tensions?
So I think there's no quarrel about this, right? We are heading towards a world where disputes are increasingly shaped by the supply chain structures, foreign investment protection, energy transition conflicts, sanctions, national security considerations, technology and data governance. And all of these constantly change depending upon the foreign policies of different countries, the foreign policies of various organizations, etc., etc. So, according to me, international arbitration will likely see, and it is actually currently also witnessing, a huge growth in the energy, ESG, and tech related disputes. This also includes disputes involving precious metals. As we know, there are global shortages of lithium and other precious metals, which are really essential in manufacturing of, uh, batteries for cars, servers for AI. So all these aspects are going to affect the evolution of disputes, and depending upon how foreign investment also flows in each of these sectors, that also will determine how these disputes will evolve, what countries it will include, what private entities it will include. Because let's not forget, international arbitration is not just between two commercial entities. International arbitration can be between one company against the other. It can be between one company and a state, a sovereign state. It can be a private investor against a state. So there are various permutations and combinations in which international arbitrations unfold. And each of these aspects are equally and individually responsible in their evolution. And if I'm talking about litigation and specifically commercial litigation, considering my experience in India, and obviously, as I've already covered, the fact that litigation is seen more from the lens of domestic jurisdiction and national laws than cross border, even though they can be cross border. But commercial litigation in India, on the other hand, is, I think, becoming more sophisticated by the day, with courts being increasingly comfortable handling complex commercial matters. Like, for example, in Delhi, there is a specialized commercial court which is entrusted with the responsibility to handle only commercial disputes. And this is in line with several developed jurisdictions which are continuing and which will continue to give importance to commercial disputes. So, and with this evolution, what also then becomes important is how cross border enforcement also shapes. So I think all of these, it's an interesting space to be in. And I think, given the rapid shift in geopolitics and technology and supply chain restructuring, I think we will likely see a surge in disputes now, because over the last 10 years disputes have been a little stagnant, if not increasing. Data of all leading institutional arbitration institutes across the world would show that disputes are not increasing. It's a different thing to compare how many disputes are actually landing up in before these institutions and which are not, or which are being settled outside. But if you see figures, there is a dip. There's definitely a dip. So it'll be interesting to see how all of this shapes the coming decade.
Yeah, that's such an insightful point, seeing the growth of law overall, whether it just be in international arbitration through energy sectors or tech sectors, or commercial litigation where courts are being able to handle more complex matters, this growth in law will be met by the increase in disputes, which I think will be an interesting change to see over time. So, finally, what advice would you give to aspiring law students wanting to pursue a career in international arbitration or commercial litigation?
Um, so, I mean, apart from inculcating the qualities I had earlier highlighted that a good litigator should have, I mean, everyone develops and evolves at their own pace. But if you have a broad idea of what it takes to really hone these skills, I think you have already won half the battle. But my three pieces of advice would be: first, to build strong fundamentals. So, which would involve research, drafting, and clear and succinct writing. These are, according to me, some of the non-negotiables, as is the buzzword these days. Second would be to seek early exposure. I really believe that law students should try their hand at moods. They should focus on moods involving subject matter which they most closely relate with or they want to work on. So if someone is aspiring to handle commercial arbitration and litigation, then they should aim to compete in moods like Wiz and other similar moods that really have commercial dispute focused moot problems. Then at the same time, it's extremely important to take up clerkships with judges who are focusing on commercial disputes, to take internship and paralegal opportunities with law firms, work with independent practitioners who are focusing on commercial disputes, so that you're really able to get a taste of how real world practice of commercial litigation looks like. And you're able to, I won't say alter or improve, but really assimilate your aptitude and what it takes to be a commercial litigator or an international arbitration lawyer. Last would be to stay as global as possible. Arbitration is international by nature, especially when we talk about international arbitration. So it's really important that a law student takes every opportunity to engage with comparative law, try and understand more about how various institutions around the world function, what are important geopolitical and international developments, how is the foreign policy of a country changing, how is that affecting investments, flow of capital, flow of technology. So even general awareness about all these global updates is extremely important, so that you are focused and you develop a holistic understanding of the ground realities, as I had earlier touched upon. So I feel these would be my three strong pieces of advice.
Those are some great pieces of advice, building strong fundamentals, seeking early exposure, and just staying global for a law student, I think are some prevalent kinds of bits of advice that they can really carry forward. So
Yes.
thank you so much for your time, Advocate Mago. And also thank you so much for making this episode very easily comprehensible by our audience. And to all my listeners, court is now adjourned until next time with the fine print.